The chair is pleased now to recognize Steve Cohen, the gentleman from Tennessee.
Thank you, Mr. Chairman. And I just want to emphasize that Congressman Waters said something about this side of the aisle. I don't know if she was referring to Congressman King, but I'm only on this side of the aisle because we have a majority. I want to ask the attorneys, particularly Mr. Washington first, about the hate crimes. My staff and I have been looking at this for a couple of weeks. Pastor Derek Hughes of Springdale Baptist in Memphis called me and asked me, can we make this a crime to hang a noose? I know that there are laws about swastikas and cross burnings and nooses of the kind, but don't they have to have some specific intent, not simply the display of an object, but the object with a particular intent?
Yes, that is among the things that have to occur.
And in this situation, is it because it was on school property that makes it a hate crime?
What makes it a hate crime is the idea that there was a threatened use of force, that it was to intimidate, injure, interfere with some folks because of their race while they were exercising a constitutional right, and that is going to school. What was sort of confusing here, and there is agreement amongst the panel, except for the fact that we don't agree as to whether these particular folks could have been prosecuted. These particular folks would not have been prosecuted, but they could not have been prosecuted. It was impossible under federal law, as written today, for us to go after these particular juveniles.
Why?
Because they were under the age of 18.
Okay, that's their age. Now, you say that did these individuals make a threat of violence?
Well, that is among the kind of things that we'd have to prove in court, and we'd have to go and make our best case, of course. And if the evidence...
So the simple display of a noose is not a hate crime?
That's correct.
Right. And so it has to be with some intent and something else to it?
There are elements in the statute that we have to prove in court.
And yes. Then what if it was not on a school ground or in a federal building? What if it was simply a noose at somebody's home? Would it be sufficient that they were their constitutional right of having pursuit of happiness or whatever? I don't know what, that's not a constitutional right. But would there be places that are not covered because of the locale of the placing of the noose?
That's possible, but there are other statutes possibly that we'd look at if there was racial animus involved.
Well, you say there would be the ones you might look at. Do you think, is there maybe a void somewhere that needs to be filled where the exhibiting of a noose, the burning of a cross, the painting of a swastika with an intent to deprive a person of their constitutional rights needs to be passed, either with that language which I just mentioned or some other language to fill any void?
Actually, I think you just quoted the elements of a federal statute today. 18 U.S.C. 242 or 241 already exists to cover the situation that you just indicated.
So you think it's pretty filled?
Well, it's pretty filled. Where we get into, I guess, significant discussions is where's the limit between speech versus
right.
Criminal law.
Right. So you've got to have some element of violence that has been alleged to have occurred to make this a hate crime. Is that right?
We would like to see that.
You say you'd like to see it. It's always been my thought. Maybe it's just the conventional wisdom that the hate crime is violence and not speech. And a noose, while objectionable as a swastika or burning a cross, is speech. What do you have to add to that speech? Don't you have to have something besides speech to make it a hate crime?
Yes. Just as an example, 18 U.S.C. 245, when you get to the punishment section, if there is no injury, it's not a felony. It's a misdemeanor. So that's one. So when you back up into the elements of the crime itself, you do need some use of force or threatened use of force.
Okay, great.